Good afternoon, my name is Trishawna Simpson and I'll be advising you on the matter of whether or not you are an employee of Create Limited. Currently, most rights under the main statutes, such as the Employment Rights Act 1996, applies only to employees. The way in which you were employed, therefore, may or may not give you access to these rights. One of the most important hurdles to overcome in order to access a number of these primary employment rights is to establish if you are an employee. Being an employee is imperative because only employees, for example, are able to bring an action for unfair dismissal. Or in your case, it is important that you are an employee in order to receive a bonus. To start with, you may choose to look at Section 2.3 of the Employment Act 1966, which provides a definition of what an employee is. Under this legislation, you are an employee if you work under a contract of employment, i.e. if you have a contract of service rather than services as defined under subsection 2. The definition of employee and employer contained in the specific statute is not usually helpful in determining an employment relationship between two parties. So, when disputes such as those relating to your case arise, the courts resort to the common law test to determine employee status. You are advised to look at these tests in order to identify whether or not you are an employee. The simplest of them is a control test. This poses the question of whether the managing director of the company has the right to tell you how to design the software. From the facts of the case, it is obvious that he or she would have some degree of control as to the design of the software, and you would therefore be regarded as an employee. As you may have imagined, this test was often seen as too simplistic, especially in recent years where we have highly skilled and professional workers like yourself, whom possess skills beyond the ability of their employers to control. In fact, you may choose to argue that as a graphics design company, the managers of Create have very little knowledge on the creation of software, and so the extent of their control was likely to be inadequate. The case in point here is the case of Worth Brothers Limited, which highlights the point that the more skilled the employee, the less control is present. Furthermore, in McDonald and Evans, Lord Denning claimed that the need for control is less important, and the courts should instead focus on the integration of an employee in a company. He claimed that the greater the integration within the business, the more likely the worker will be an employee of the company. Create's primary business is graphics designing, and so the integration test would examine if the service you provide integrates with this activity. If so, you are probably an employee. The control required within an integration test depends on the circumstances of your performance. For example, the fact that you are required to work a minimum 20 hours per week on Create's premises does imply an element of control, and to some extent may suggest that you are an integral part of the business. On the contrary, the fact that you have to submit an invoice if you work more than 20 hours per week suggests that the hours you work and the way in which you are paid are not under Create's control, therefore you're less integrated. The court may also take into consideration the fact that your service can be cut off from Create and the company may not suffer a loss. In practice, they will draw on the fact that software designing is a separate business from graphics designing, thus is not part of Create's organizational control. Therefore, the service you provide is done on behalf of Create but not integrated into that business. Nonetheless, the courts will also consider that the company pays you holiday and sick pay, as stated by Lord Denning. In the case of McDonald and Evans, this is a clear indication that you are part and parcel of the organisation. Moving on, nowadays the courts look at every term within a contract to see which applies to an employment relationship and which applies to a self-employed person. This test is called the economic reality test, and as in the case of market investigations 1969, the courts will assess the reality of whether you're in business on your account. This includes assessing factors such as your freedom to hire others, providing your own equipment, and investing in your own business. Normally, if you receive monthly salary or a weekly wage for when you work under 20 hours, then it is more likely to be considered that you are an employee, even though some cases such as Carmichael and another does not show this as an important indicator. The case instead highlights that mutuality of obligation between the employer and the individual is a much more important factor that the court should use to decide whether or not a contract of employment exists. So the question would be, does Create Limited have an obligation to provide work, and if so, are you under an obligation to accept it? In addition, they may ask the question of whether you have an obligation to perform your service in person. It is crucial to employment status that you are able to perform your service in person. In Express and Echo publications, for example, where a contract allowed a worker to provide substitute if he was not available, the Court of Appeal held that this prevented the worker from being an employee because there was no obligation to do the work personally. The courts may also take into consideration that Create Limited has provided you with a desk and a laptop, which are undoubtedly essential for the completion of the task. Dependence on these facilities could indicate an employee-employer relationship. Also, the fact that you pay your own national insurance, income tax, and is eligible for sick pay and paid holidays means that you are more likely to have a strong status and be considered as an employee. A more modern test for deciding employment status was established in ready-mix concrete, where the three-part test was developed. This is known as the multiple composite test, which allows all the factors to be taken into consideration. Applying this test, the courts will look at the substance and not the form. For example, in the case of Weight Watchers Limited and HM Inland Revenue, the contract tried to paint a picture of someone that is self-employed. However, when the court looked at how the individual actually worked, it was concluded that they were in fact employees. In practice, the court will look at the reality of your performance and not just what the contract says. The courts will also look at the intention of the parties in order to determine employee status. This is shown in the case of Fergus and Dawson. It is not necessary for you to meet all these tests, and unless the relationship is dependent solely upon the true construction of a written contract, whether you are engaged under a contract of employment is a question of fact for a court or tribunal to determine. The weight that the courts attach to any particular factors appears to be a matter of discretion. This may be subject to review if they commit errors of law in their identification of the relevant test or in their application. Thank you.